Hello, Attorney Joe Jamanco, Managing Partner of Jamanco Law Partners, a Bolingbrook-based litigation law firm. Here today to talk to you a little bit about debt collection lawsuits, specifically where you're named as a defendant in a case. We get calls fairly regularly from clients who have been named as a defendant in a debt collection lawsuit. And what I mean by debt collection lawsuit is simply that. A person incurs a debt. At some point, the creditor stops making phone calls or sending letters, and they file an actual lawsuit. Most frequently, these come from debt buyers. A debt buyer is a company specifically that goes out and buys debts of other entities, oftentimes credit card debts or past due loans for vehicles, things like that. They then file suit against a defendant and try to collect on those monies in court. There are a few basic things to keep in mind when it comes to debt collection lawsuits. First of all is that they're very defensible. In fact, of all the cases that we have, they are some of the most defensible cases because of the way that they pursue them. Now, there's nothing illegal about pursuing a debt collection lawsuit. There's nothing illegal about transferring a debt. But what we tend to find with many of these creditors is that they do a very poor job of maintaining their records. And the reason that's important is because as a plaintiff in any case, it's the plaintiff's responsibility to prove their case. If you walk into court as a plaintiff, it's not sufficient to bring in documents at trial and ask the judge to simply look at those documents. You got to have witnesses. You got to have people testify to those documents to actually introduce them in accordance with the rules of evidence and procedure. So the reality is, oftentimes these debt collectors, when they purchase a debt, they purchase not just simply your debt, but they purchase hundreds or even thousands of other debts at the same time. Many times the paperwork for the transfer of the debt is terrible. And because of that, it gives us an opportunity when defending these cases to require the plaintiff to prove their case, to prove ownership of the debt, the dollar amount that's actually accurate, and to make sure that they're the legal owner of the debt. Now, while this is legal, while you can transfer a debt and a person can buy a debt and collect on a debt, you have to follow the law. And many debt collectors simply don't do that, which then provides our clients with an opportunity to defend those cases. Oftentimes we have those cases resolved one of three different ways. We force the case to actually go to trial, and we actually go to verdict on the case. Sometimes you win, sometimes you do lose. We tend to have an excellent record, though, at trial, and currently only have one case that's actually gone to judgment against one of our clients. The second way is that we force a dismissal. Now, there's two types of dismissals. There is what's called a dismissal with prejudice, and that's one that is final. Once it's done, the case cannot be refiled. The other type of dismissal is a dismissal without prejudice. Now, a plaintiff in the state of Illinois has one chance before the case goes to trial to take a voluntary dismissal. And in doing that, all they have to do is pay your filing fees, and then they can refile the case within either a year or before the end of the statute of limitations period, whichever is longer. So a dismissal without prejudice, it's a good thing. It's just not necessarily final. The third way that some of these cases are resolved is by a settlement. Now, I have never once settled a case with a debt collector and told my client to pay 100%. I never would do that. It makes no economic sense whatsoever. Oftentimes, we see the debts from debt collectors settled for between 25 and 30 cents on the dollar. The actual amount that they're willing to settle for, it varies greatly. It depends upon who our client is, whether or not the debt is collectible, assets and liabilities of our client, as well as the creditor and the evidence they actually have to support the case. We've had cases as large as nearly $1 million that have been settled for literally pennies by comparison. We had one debt that was for over $900,000 that was settled for $12,500. Now, that's not typical, but we do have debts commonly that settle between 20, 25, 30 cents on the dollar, as high as 50 cents on the dollar. Very seldom do we see our clients paying more than that. As a result of that, these cases are both defensible, and economically we can actually make it work for the client as well to retain us to assist them. Now, you don't have to have an attorney as an individual. You can defend these cases yourself, and in small claims court, some people choose to do that. The challenge that you're going to have is that as a litigant, you're going to be required to follow the rules of evidence and the rules of procedure just like any attorney would. While some judges may cut you a little slack, at the end of the day, they don't have to. And the problem is that you need to know what the law is, what the evidentiary objections are, and be able to spot issues that come up in a complaint or in the evidence as the case is actually tried. As a result of that, it's just frankly simpler to have an attorney handle the case for you, one who knows what they're doing, and can both defend the case and or work out the best settlement for you possible. So in the end, debt collection lawsuits are frankly defensible. There are many other types as well. This is just one sample. If you have a debt collection matter and you want to talk to an attorney who understands these cases and tries them and has experience with them, give us a call at 630-635-5555. Again, our number is 630-635-5555. We provide free initial phone consultations. We'd be happy to talk with you about your case. My name is Joe Jamanco, Managing Partner of Jamanco Law Partners. Good luck out there.